This is Bloomberg Law with June Grasso from Bloomberg Radio.
$200 instantly. Just for betting $5. DraftKings, listen to me. You listen good. I appreciate you for recognizing how valuable my time is. But instantly, stop. You're not going to make me sweat a little bit? Feel some extra bumps in my chest while the game is going on? Oh, look, wait a minute. There's my $200.
Sports betting apps are fast. You can place multiple bets on multiple games within seconds. And of course, there's the accessibility right on your phone at any time. There's expected to be more sports betting this NFL season than ever before. But consumer bankruptcy attorneys are starting to see the downside to the apps, as gambling debts play a more prominent role in bankruptcies. In fact, a new study finds there's a 28% increase in the likelihood of bankruptcy filings in states with legalized online sports betting. Joining me is Evan Ochsner, a bankruptcy reporter at Bloomberg Law, who's researched and written about this. Online gambling is pretty new in the legal scheme of things. How many states have legalized it?
This all stems from a 2018 Supreme Court decision that cleared the way for states to legalize sports betting. And so far, about 30 states have legalized online sports betting since that decision. There's some additional states that have legalized sports betting, but not online, still only at physical locations like casinos. And so you have a varied landscape right now of states that have legalized it and some states that haven't. Missouri is set to go to the ballot in November. They're considering whether to legalize sports betting at that time.
And I assume that billions are involved. How many billions?
The number that I highlighted in my story was a projection from the American Gaming Association, which projects $35 billion in legal sports bets to be placed throughout this NFL season. I don't know what proportion of that is online, but the $35 billion projection is up significantly from $27 billion last year.
Wow. You talk to consumer bankruptcy attorneys, and they say that online sports books betting have pushed clients into Chapter 7 or Chapter 13?
Yeah, that's right. I chatted with consumer bankruptcy attorneys in states that have legalized online gambling, and they said within the last few years they have seen an increase in clients that have had issues of financial distress that were tied to online sports betting. One attorney told me this is a phenomenon that he's just started to see within the last 5 years. And another told me that he's seeing the largest gambling debts when his clients are doing betting online. The issues that they see are generally most pronounced among young men, and some of the research that's been coming out in recent months also finds some of the strongest financial downsides among younger men.
And it's not necessarily because of huge bets. It can just be a lot of small bets.
Yeah, that's right. That's a great point. And a lot of times they'll see their clients just rack up bets over time, sometimes $10 bets, sometimes $100 bets, but that can all build up. I also saw one case where the debtor admitted himself that he was trying to make something out of nothing. He was struggling financially and actually placed some bets right around the time of his bankruptcy filing and right after. And that drew the attention of a creditor who didn't like that type of spending. But yes, it can be small bets that just add up over time. And the consumer attorneys, though, did emphasize that this is a problem that's often combined with other financial issues. It's not necessarily a giant gambling debt that pushes something into bankruptcy. There's usually other things going on. And sometimes, too, you'll see their clients who, say, gamble away their money in cash and then rack up debt elsewhere because they don't have cash to meet other needs like groceries or rent.
One attorney told you he's had clients who blew through their 401k savings.
That's right. He was telling me about clients who, he said, make a good living, make a high salary, but blew through their savings accounts and their 401k. And then that's when they kind of have that moment of reckoning and reach out to a bankruptcy attorney.
Can gambling debts be discharged in bankruptcy?
Yeah, gambling debts generally can be discharged in bankruptcy, but it's not always super simple, at least according to the bankruptcy attorneys I talked to. They said they generally try to design a case so that issues around the gambling debts don't arise. One lawyer I talked to says she won't file a case until she can submit 3 months of clean financial records that show no gambling transactions. She said with one client she had, that was a big struggle. They were having a hard time staying away from the sports books, so getting to 3 clean months was an issue. And again, even though it's dischargeable, it can really cause some issue with the creditors or the trustees who help administer these bankruptcy estates, because sometimes it's viewed as irresponsible spending by someone who's already underwater. An attorney I talked to suggested that he frames it as an entertainment expense sometimes, and he said there's nothing illegal about it. You can disagree about how people spend their money on entertainment, but as long as it's within reason, there's nothing inherently wrong about it in the bankruptcy context. And another lawyer I was talking to, I mentioned I was searching court dockets for examples of some sports gambling cases, and I told him I was having a hard time finding times where it came up, and he said that's intentional. If a lawyer designs their case correctly, they can prevent those issues from coming up at all.
Are there any circumstances where you can't discharge gambling debts in bankruptcy?
It generally is dischargeable, and it's dischargeable under the bankruptcy code. An interesting case I'll highlight is a creditor who objected to $13,000 in bets that were made by this debtor around the time and during his bankruptcy. And the judge found that even that was a good faith debt and didn't merit the case being dismissed. He said that, yes, it was bad judgment, but bad judgment doesn't equal bad faith. And if it was a bad faith debt, that's where you run into issues of dischargeability. But as one lawyer told me, his clients didn't gamble to lose. It's not like a lot of gamblers and problem gamblers don't think they're going to pay the money back. They fully believe that they're going to win and dig out of that hole. So it's not a bad faith debt in the sense that they knew that they weren't going to be able to pay it off.
You mentioned that one lawyer waits until her client has 3 months of financial records without gambling payments. I mean, what happens if a client keeps gambling during the bankruptcy? Does that show up?
Yeah, that's a good question, and it can. And that's where the one lawyer was talking about framing it as an entertainment expense. An individual debtor will submit a proposed budget to the court, and let's say that in my budget I propose $300 a month on entertainment, so I could still theoretically gamble $200 a month and, have that as an entertainment expense, is how this lawyer talked about framing it. And then in the other case I mentioned, some of the bets of this chunk of $13,000 by the debtor who admitted that he was trying to dig himself out of trouble, some of those bets were made while he was bankrupt, and that's part of why the creditor argued that it showed that the bankruptcy was in bad faith. But again, the judge disagreed with that and determined that it didn't equal bad faith.
Did any of the other lawyers that you spoke to make an effort to help the clients with their gambling problems?
Yes, and essentially the lawyers who I spoke with suggested that helping the client with the gambling problems also helps smoothen the bankruptcy process. It's helpful essentially to be able to tell creditors and a trustee that their client is getting treatment. One lawyer told me that before he files a case, he has his clients sign up for self-exclusion lists, which is something that you can do at casinos or now at online sports books, where if you know you have a gambling problem, you can essentially ban yourself from that gambling platform so you don't accrue any additional gambling losses. And that's something that's helpful for the lawyers to be able to tell a court, is that their client is no longer gambling because they've signed themselves up for these lists.
So the betting apps themselves, I mean, I take it they're encouraging more gambling. Are there any ways to limit yourself on a betting app? I mean, I have no idea because I've never placed a bet on a sports app, but I know people who have.
I haven't either. And yes, the betting apps allow you to place limits on how much gambling activity that a user participates in. So you can set limits on, say, how much money you want to bet. The gambling apps and some of the lawyers I talked to also said it's helpful because they provide rundowns of how much money a bettor loses or wins. So essentially think of it as like a monthly statement that shows you your betting activity. That makes it easier for players to keep track of their wins and losses. Compare that to someone who's going to a casino and just playing slots and has a harder time keeping track of it. I also talked to one expert who said that bettors historically overestimate their wins and underestimate their losses. So having the kind of printout and being able to see wins and losses, I think, is intended to be helpful as far as giving people an idea of their financial picture.
It sounds like you had to do digging for this. Have any studies been done about how much online gambling contributes to bankruptcies?
Yeah, there's been a couple interesting studies that have come out just this summer. One looked at states that have legalized online betting, and in those states it found a 28% increase in bankruptcy likelihood. They saw that online access drives most of the effects they observe as far as financial harms. They found that the legalization of sports gambling decreased consumer financial health. Another study found the strongest adverse financial effects among lower income households in states with legalized sports betting. They found that legalized sports betting decreases net investment and increases overdrafts. There was a third study that has not yet been peer reviewed and came out just a couple weeks ago that did not find a statistically significant increase in self-reported financial distress.
So in the states that are considering it, what's the upside to having online gambling in your state?
Some of the arguments I've seen amount to tax revenue. This is something that states can tax and find another revenue stream. It was highlighted to me by one of the experts I talked to that that's a big motivation for some of these states is to bring in additional revenue. And in some of the states, the entities that are arguing against it are traditional casinos who don't want people to just stay at home and bet. They want them to have to come in and bet at their casino.
So we'll see what happens with the ballot initiative in Missouri. 6 states tried but failed to legalize sports betting during the 2024 legislative session. They are in alphabetical order: Georgia, Hawaii, Minnesota, Missouri, Oklahoma, and South Carolina. Thanks so much, Evan. Great story and research. That's Evan Ochsner, Bloomberg Law bankruptcy reporter. Only 8 weeks remain for President Joe Biden to complete his efforts to remake the racial, gender, and professional diversity of the judiciary. The task is complicated by the pressures of an election year and a narrowly divided Senate. Joining me is an expert in the judiciary, Carl Tobias, a professor at the University of Richmond Law School. Carl, where does Biden stand in comparison to Trump?
Biden now, today, will confirm 2 people, so he will have 161 confirmations at the district level and 43 appellate. At that same point in 2020, Trump had 151, 10 fewer at the district level, but 53 appellate, and so that's 10 more at that point in time, and he ended with 54. So that's where we are.
So only 8 weeks of the Senate session remain, including the lame duck session. How many nominees are in place, and how many do you think they can get through?
Well, I think they can confirm the 6 appellate nominees. 1 or 2, I think, are controversial. But then at the district level, there are 16 district nominees on the floor. I believe 10 or 11 of them will easily be confirmed because they had bipartisan Senate Judiciary Committee approval. And so you have 5 who may have somewhat closer votes. Then there are also 4 district nominees who've had hearings but have not had committee votes, which they'll have either Thursday or the following Thursday. And then there are about 6 or so other newer nominees who still would need hearings and committee votes and floor votes. So that's what we're looking at in terms of what we have now, though I think the White House is committed to going further in the lame duck session and actually holding hearings then, and may still have nominees this month in September who could still make it through during the lame duck with hearings and committee votes and floor votes. But we'll see. At some point, it's going to be too late to nominate and move people through the process. But I don't think we're quite there yet.
There are some who there's been opposition to. Tell us about those. One would be the first Muslim federal appellate judge, if confirmed. Why is his confirmation being opposed? Adil
Mungi for the Third Circuit. And the Republican senators have criticized him, saying that he is against law enforcement, which is not true, and also that For example, they asked him questions about what his views were of the conflict in Gaza now. And so some GOP members raised questions of his support for Israel or support for solutions in Gaza that just muddied the waters. So we'll see what happens. But I think that he will be confirmed at some point, and it may be in the lame duck.
A number of national Jewish groups came to his defense, saying that Republican lawmakers inappropriately grilled him about his views on terrorism, Israel, and anti-Semitism. Another nominee who's facing challenges is also a Muslim, Mustafa Kusabhai, who's been nominated for Oregon's District Court.
Well, Republicans criticized him, I think, for some reasons that were sort of analogous to Mungie, but not exactly the same. He had written some articles, I think when he was in law school, that they thought and argued were not appropriate. Even some of them talked about him as a Marxist or whatever, but those were articles written a long time ago. There were other criticisms. He's been a magistrate judge for some time in Oregon, and they were concerned about pronouns and that type of thing in his courtroom. But I think that he's likely to be confirmed, but it may be close. And so that's his situation.
It just happens to be those two, or is there a racial component to it?
I don't know. Some of the supporters of both of those nominees are saying what you just suggested, but it's not quite that blatant. But they're concerns about whether that might be the case.
There, I believe, are 6 appellate picks outstanding.
Yes.
Do you think that the Judiciary Committee and, Chuck Schumer should prioritize the appellate picks because they have a lot more influence?
Yes, I think you're correct, but they also need 30 hours of post-cloture debate time as opposed to 2 hours for district nominees. And so he looks to be leading so far, this week at least, with the district nominees because they consume less time and they're often less controversial, as you suggest, because they mostly do trials and move cases and are really nominated for their competence in being able to keep up with heavy dockets, as opposed to appellate judges who make more policy and their rulings govern multiple states within the appeals courts. And the GOP and Democrats, too, in the Trump years, focus more on those kinds of nominees because they have outsized influence, as opposed to the large number of district nominees. But district nominees, of course, are important because they make the record and they hear the facts, but they don't bind anybody, even in their own courthouse, with their rulings, as opposed to appellate judges.
The Democrats hold a 51-49 majority, but can you really consider it 51-49 because Joe Manchin has said that he's not going to support any nominees who don't have Republican support?
That's true, and that's unfortunate. But yesterday he did vote for Abelson, and it was bipartisan because Lindsey Graham and Susan Collins both voted for Abelson, and will do the same today, I expect, for Jeanette Vargas for the Southern District of New York. So on the more controversial nominees, they may lose that vote, you're right, but there won't be that many of them. And there'll be some offsetting, too, because remember, for example, yesterday, there were 7 GOP members who did not vote. One of them, of course, was Vance, and he'll be on the campaign trail probably for the next couple months.
We've talked about before that home state support, the support from home state senators, isn't required to advance appellate nominees. But some Republicans have criticized Biden for not adequately consulting them on appellate vacancies anyway. So North Carolina Republicans Tom Tillis and Ted Budd said they had enough votes to sink Park's Fourth Circuit nomination. Will that play into more of these nominations?
Well, the White House has said that it did consult and that they worked very closely with the North Carolina senators, and 4 candidates, the North Carolina senators forwarded and suggested, recommended were considered by the White House. And in turn, the White House had 4 people it was considering and ran those people by the senators, including Ryan Park, who became the ultimate nominee. And so Biden just made a choice, but I think he seriously considered the 4 people the senators had sent forward. So there was a fair amount of consultation that went on, and ultimately they chose someone else, Ryan Park, who is well qualified and was very articulate and clear at his hearing and answering difficult questions from GOP senators. So I'm optimistic that he'll have a positive vote.
Greg Nunziata, who was the former chief nominations counsel to the Senate Judiciary Committee during George W. Bush's administration, said, "You never want to be a judicial nominee who's counting on Senate action after August in an election year."
Yes, but they're there for 3 weeks now. And what we've seen this week is the district nominees coming forward. A number of them will be confirmed this week and then on into the next couple of weeks. And then they leave to campaign, I think, around the 30th or so. But they'll be back for the 5-week lame duck that starts on November 12 after the elections. And so there seems to be a fair amount of time left. And the commentator is correct that there will come a time when it's too late, but the White House has said, and so has Senator Schumer, the majority leader, that they intend to go as deeply as they can into December. I think they're going to be committed to confirming as many people as they can.
Suppose Democrats lose the Senate in November. Will that make it harder? Will there be more opposition to pushing Biden's nominees through?
Well, there could be, but the majority rules, as happened in 2020, if you remember back to that period in time. And actually, after Biden defeated Trump in the election, Trump nominated and confirmed one appellate judge on December 15, 2020, and a dozen or so district judges. So that's the relevant precedent. I think the White House is committed to moving forward regardless of who might have the majority after the elections. And that's their prerogative as the majority until the new Senate comes in early January.
Okay, we'll see what happens in the next few weeks. Thanks so much, Carl. That's Professor Carl Tobias of the University of Richmond Law School. Coming up next on the Bloomberg Law Show, a 7-year fight over a $70,000 Tiffany engagement ring. This is Bloomberg. And if you do decide to put a ring on it and the engagement is broken off, who gets the ring? Well, it depends. And that's why a fight over a $70,000 Tiffany engagement ring has reached Massachusetts' highest court. A would-be groom broke off his engagement because he suspected his fiancée was having an affair, something she denied. So he took her to court to get the pricey ring back. That was 7 years ago, and the litigation is still going on. And now it will be up to Massachusetts' highest court to decide who gets the ring. Joining me is Peter Walzer, founding partner of Walzer Melcher Yoda. Are lawsuits over who gets the ring the last remaining types of litigation over broken engagements?
Yes, that's true. All the heart-bomb statutes, which were laws in the 40s and 50s where you could sue for a broken engagement, have been abolished in all the states. So this is sort of the vestige of that. This is one of the last forms of litigation relating to broken engagements. The older laws in this country did allow people to sue over a broken engagement, but those are antiquated, and courts have been inclined to get rid of fault in relationship litigation, including divorce, broken engagement, that kind of thing.
And in Massachusetts, in a case over who gets the engagement ring, it depends on who's at fault for breaking off the engagement? That's the issue.
Yeah, and other states like Texas have that kind of law. In Massachusetts, it's case law, not statutory law. And if you could prove it was the other person's fault for breaking off the relationship, you could keep the ring. If it was your fault, then you'll keep the ring. That involves a lot of litigation, and in this case, it went from the trial court to the appellate court to the Supreme Court, which is a lot of money, even for a $70,000 engagement ring from Tiffany.
Let me ask you this. By at fault, if you just break off an engagement, are you at fault, or is it more than that?
I think it's more than that. In this case, the guy, the giver of the engagement ring, accused her of having an affair. He saw some posts on social media that she was with a guy. Her claim was that it was just an old friend and she wasn't at fault. So this causes a court to have to decide who is at fault. Was she really cheating on the guy, or was it an old friend and she made a mistake?
In this case, the trial court concluded, as you mentioned before, that he was mistaken and he had to bear the fault. So she got to keep the ring, as well as more than $40,000 for planned dental work he'd promised her. Is that over and above, or is that included too in these kinds of lawsuits, like you promised to do this once we got married?
Well, that's probably a different issue. That's a contractual issue. The court found that there was an oral contract for him to do this and enforced it. It probably had nothing to do with the engagement. The engagement ring was a separate issue and dealt with separately. But if you promise somebody and the court finds there's a contract and there's consideration, I don't know what the consideration in this case was, but, that is, I would say, unusual, and maybe is why this case went up to the Supreme Court, because it was so ridiculous.
The trial court's decision was reversed by an appeals court, and now the case is before Massachusetts' highest court. What were the arguments there?
It's a special category. If you promise to marry me and you break it off and for no good reason, why shouldn't I get the ring back? And in fact, in many states like California, if the engagement is broken off for whatever reason, you get the ring back. Other states treat it differently, that no matter what the reason, the person who receives the ring keeps it. But California, for example, not only do you get your ring back, but if the person says, I can't find the ring, which you can imagine how common that is, you have to pay the value of the ring. So if you say, I can't find it, well, too bad. I want the money for the ring.
Wow. Why isn't the ring considered a gift?
Well, it would be considered a gift, for example, if it was a birthday gift or a holiday gift, Christmas or Hanukkah, whatever. But in this case, there's a promise, and you broke your promise. I want my ring back.
The highest court in Massachusetts could just decide this based on the law as it is, or could they establish a new law in Massachusetts more in line with other states?
From my reading of it, they're likely to set a precedent one way or the other, that it's a conditional gift. If the engagement is broken off for whatever reason, the ring is returned, or they could treat it as an unconditional gift. The person keeps the ring no matter what happens. And I guess it depends on who you are, who's the giver and who's the receiver. But, if there was a good reason for breaking off the relationship, for example, the person was married to somebody else, you can imagine situations that you would want your ring back, or there was some kind of fraud, you'd want the ring back. But the court doesn't want a lot of litigation over this because it's expensive. And it's basically he said, she said, or he said, or she said, she said. It's not necessarily opposite sex, but it's a special legal relationship getting married, and it's different than a holiday gift. And people will spend a lot more money on an engagement ring than they would on a holiday gift. So that's why it's treated differently under the law.
Is there ever litigation over a ring in a divorce?
Yeah, and I've had that one. That is really tough because if it's an expensive ring, more than the parties would ordinarily spend on a gift to one another under at least California law, unless it's in writing, you can get your ring back or your jewelry back. And I had that in one case where the guy had cheated on my client, and he gave her a ring to make up for it, which was worth about $75,000 at the time, probably 20 years ago. The court ordered that she return it to him because it was not in writing and it was an extraordinary amount of money. My client was not happy. I was not happy, but that was the result.
So in a prenup now, you should write, and I get to keep the ring, or he gets to keep the ring?
Yeah, we definitely put that in the separate property schedules and list the ring, because we don't want a situation, and you have to say, even if we don't get married, even though the agreement is not valid unless you get married, except for the ring, I get to keep my ring.
And in this case, they're fighting over a $70,000 ring for 7 years, and I wonder how much the legal fees are going to take up.
Hundreds of thousands of dollars. I mean, that is crazy. And, you know, maybe it's a publicity stunt. Maybe it's about something else. Usually it's about somebody's feelings, but it is crazy. But $70,000 is a lot of money, but once you're in, you give up. I mean, the fact that this made it to the Supreme Court, maybe the lawyers are funding it so their name's in the paper. Who knows?
So you think there should be a Brightline rule in all the states?
Yeah, it's more of a symbol, I would say. It's an emotional symbol for people, so it's not like your ordinary gift of something. And there's a lot of feeling into it, but the courts really need to take charge, or the legislatures do, and make a Brightline rule. Either it's a gift outright, no conditions, no matter what, or it's a conditional gift. If it's broken off, you get the ring back. It's probably more practical to say if you are inclined to give an expensive gift on the condition of getting married, you know, you've given it, no conditions made. It doesn't matter if the relationship goes through. It's on you to ensure you pick the right person and you don't do this on a lark or on a whim. So if I was writing the law, I would go for it's a gift no matter what, and if you give it, whether the wedding is broken off. On the other hand, though, you could think of people deceiving people, saying, let's get married, I love you, they get the ring, and then they break off the wedding. So these things are not as easy as it seems, right?
Not at all, although I think Montana has made it easier because the Supreme Court there, more than 20 years ago, decided a no-take-back policy that treats the ring no different than any other gift. So that seems pretty easy. So,
you know, it's interesting because in the 60s, my dad was on the governor's commission for no-fault divorce in California. And in 1970, we enacted the no-fault statute in divorces. And that's carried to pretty much most states, not all states, but most states. But now there's, you know, it's sort of backtracking where many states are bringing domestic violence into it and coercive control. And it's getting back to a fault situation in many states like California. And what was ordinarily a, quote, simple divorce, even though none of them are really simple, it's led to a lot of allegations of domestic violence or coercive control or abuse, verbal abuse, that kind of thing. So it's funny how things cycle around.
Yes, I've seen a lot of repeating cycles in our society lately. Thanks so much, Peter. That's Peter Walzer of Walzer Melcher Yoda. And that's it for this edition of the Bloomberg Law Podcast. Remember, you can always get the latest legal news by subscribing and listening to the show on Apple Podcasts, Spotify, and at Bloomberg.com/podcast/law. I'm June Grasso, and this is Bloomberg.